Well, thank you all for coming out. As a prelude to this talk, I've been making the point over the years that the comedians are really in the same business as the philosophers because they make their livings by playing off the shades of logic and meaning tucked away in the language. It's like the case of Groucho Marx leaving a party one night, and he stops to talk to the hostess on the way out, and he says to her, "I've had a lovely evening." This wasn't it. Now, Mr. Richard Lederer from Canada used to offer us the entertainment of the history of the world as drawn from the paper of undergraduates. A list that contained items of this kind: that Socrates was a Greek teacher who died from an overdose of wedlock, that Louis Pasteur discovered a cure for rabbis, and long before that, Sir Francis Drake circumcised the world with a 100-foot clipper. But the items also contain items of this kind: that Bach was the most famous composer of his age, and so too was Handel. And Handel was huge. Handel was one half German, one half Italian, and one half English. Now, my experience has been that the interval between the line and the laugh can usually be measured in milliseconds. And yet, you'd need a certain kind of antecedent information to understand what's wrong with Louis Pasteur and rabbis. Or, it's not to say nothing of the logic of recognizing that, saying Bach was the most famous, than whom no one else was more famous, and so too was Handel, to say nothing of adding up the three halves to get one. Now, if our ears were properly trained, we'd induce the same urbane giggling when people heard the most well-traveled fallacy in our public discourse: if there are these moral truths that hold in all places, all parts of the world, they be confirmed and recognized in all parts of the world, but the very fact that they stir disagreement in all places must be taken as prima facie evidence that there are no such truths of that kind. Well, that argument reduces to this proposition: that the very presence of disagreement on any matter marks the absence of truth. Now, I record my disagreement with that proposition, and by its own terms, that should be enough to establish its falsity. It's what the philosophers call a self-refuting proposition. Now, it's curious as how many grown-ups may be drawn in by these things, and Harry Blackman founded a whole branch of our jurisprudence on a proposition of that kind. It self-destructs in 6 seconds. With Blackman, it took this form: when there's so many learned people in philosophy and religion cannot settle on the meaning question of when human life begins, there is obviously no truth that judges are in a position to declare. It's simply a self-refuting proposition, which is mean to say it comes aground in the laws of reason, with the canons of reason beginning with the law of contradiction. And my pitch to you today is that would furnish the ground of what some of us understand to be the natural law and the ground of the Constitution. I want to take you back to that moment in November 2008, that night that Barack Obama was elected president. And he was addressing a vast throng in my hometown of Chicago. And the next morning, I had an email from Jim Stoner at LSU saying, "Did you notice he said 221 last night? We've built this country 221, calloused hand by calloused hand, for 221 years. Well, Mr. Obama professes to revere Lincoln, but that number, that move, indicated he didn't understand the least thing about Mr. Lincoln and Lincoln's teaching. Lincoln famously said at Gettysburg, 407. We have the youngsters here. What year was Gettysburg? What year was the Battle of Gettysburg and the dedication? Hmm? What did he say? Who said it? We got a winner. We have a winner. Okay. If I count back 87 years, when does Lincoln take the beginning of the country? When did Obama take the beginning of the country? 2008. No, it didn't begin the time he was elected. He took it back to 1787. You students, what's happened in 1787? Constitution was drafted. For Lincoln, the country began with the articulation of that proposition, as he called it, all men are created equal, in the Declaration of Independence. From that point, everything sprang. The purpose of the Constitution was to get a structure, a practical structure of governance that would be consistent with that underlying principle, would give us a pattern of practice that would be consistent with that principle. The first Constitution was dysfunctional. We're under now the second Constitution. Lincoln drew on Proverbs to explain this when he said, "A word fitly spoken is like an apple of gold in a frame of silver. The frame is made for the apple, not the apple for the frame." The Constitution was made for the Union, not the Union for the Constitution. Okay? But Obama's words were no misspeaking. He reflected the notion of the left on the campuses these days, who reject the notion that that all men are created equal is a moral truth grounded in an enduring nature of human beings, a truth that will hold in all places. As Lincoln said about Jefferson and all men are created equal, he articulated an abstract truth applicable to all men and all times. Now, in the understanding of the founders, it went in this way, that there's certain rights grounded in the very nature of human beings. And in the style of Aristotle, we'd make our way to what was distinctively human by separating human things from the things that were either subhuman or superhuman. And so at the time of the founding, if you haven't heard it before, let me recall how the argument went. That no man is by nature the ruler of other men in the way that God is by nature the ruler of men, and men are by nature the ruler of dogs and horses. Even in this age of animal liberation, we're not signing labor contracts with our horses or cows, and we're not seeking the informed consent of our household pets before we authorize surgery on them, but we continue to think that those beings who can give and understand reasons over matters of right and wrong deserve to be ruled with a rendering of reasons in a regime that elicits the consent of people to the terms on which they're governed. No man is by nature the ruler of other men in the way that God is by nature the ruler of men. Men are by nature the ruler of dogs and horses. And Jefferson said, anyone who denies that has to assume that the mass of mankind were born with saddles on their backs, and a privileged few were born with spurs on, ready to ride them. And 42 years later, in the debate between Stephen Douglas and Abraham Lincoln, Douglas said, the country was made for white people on a white basis. If it comes down to dispute between the white man and the black man, I am decisively on the side of the white man. But, he said, if it came down to dispute between the black man and the crocodile, I'm on the side of the black man. And Lincoln, who didn't have the advantages of an analogies test or a much formal education, Lincoln said, what Douglas is telling you is that the black man is to the white man as the crocodile is to the black man. That the only way that he could make the case for removing from black people the rights that flow to them by nature is by removing black people from the circle of rights-bearing beings, by assimilating black people to the things that were subhuman. Now, as some of you study this, you have a chance to study this, you find that Lincoln's rhetoric was persistently to raise this question of the arguments of the other side and see what they would sound like if you simply shifted animals in place of persons. And he'd say something like, in the Peoria speech, Equal justice to the South is said to consist in this, that inasmuch as I'm free to carry my hog to Nebraska, you should be free to carry your slave, all of which would make eminent sense if there's no difference between a hog and a man. Now, the Declaration of Independence made it clear that the very purpose of this government was to secure those natural rights. Understand that certain rights arose simply from nature itself, that slavery was it was wrong to rule human beings the way we rule dogs and horses. Where would that argument be true? Everywhere in the world that nature remained the same and human beings were still distinguishable from animals. Get that sense? This is what we mean by natural rights. Rights grounded in enduring nature that will be the same in all places. People sometimes regard this as strange, yet this thing was utterly clear at the time. It's never out of season to recall James Wilson's line that we didn't bring forth this Constitution for the sake of inventing new rights, but for the sake rather of securing those rights we already have by nature. The English commentator Blackstone said, when we enter civil society, we give up all those unrestricted rights we had in the state of nature, including our liberty to do mischief, and we exchange them for a more constricted set of rights under civil society, called them civil rights, which are rendered more secure, though, now by the advent of a government that can enforce them. To which our James Wilson said, when did you ever have a liberty to do mischief? Or as Lincoln later put it, when did you ever have a right to do a wrong? Even in the state of nature, you did not have a right to rape and to murder. And so the laws that restrained you now from raping and murdering do not restrain you from anything you ever had a right to do. And so when the question arose, what rights do we give up on entering under this new Constitution? The answer given by the Federalists was none. Alexander Hamilton said in the Federalist 84, here the people surrender nothing. It was not part of this project to give up our natural rights, but rather to secure them. And in which case, why did it make sense, the argument went, to attach a codicil called a Bill of Rights, listing those rights we were reserving and we hadn't given up, unless you're implying now that you had indeed given up the bulk of your rights on entering under this government. I find that lawyers and judges find it to be a surprise to discover that there was a serious argument at the beginning about the Bill of Rights, and that the resistance did not come from people who were reserved about rights, but rather from people who were afraid that this new device would misinstruct the American people about the very ground of their rights. They think they'd have only the rights that were set down and mentioned. Perhaps speaking in assembly, not my right not to have my wages controlled or my prices controlled. Only the things that were set down. And you see this reflected in those lines you often hear people say. Ever hear people say, evoke, those rights I have under the First Amendment, as though in the absence of that amendment, you wouldn't have had the right to speak, to assemble. In fact, a presumptive claim to all dimensions of your freedom, quite apart from the things that were actually listed in the Bill of Rights. Now, still people can be confused about the content of natural rights. The natural right to life never meant a right to life everlasting, or that the government could not take our lives in the form of capital punishment, or the government may not put us in harm's way in defense of the country. Any law will restrict our freedom, including a traffic light which induces us to stop. Any scheme of taxation will be taking our property, drawing upon our income. The question is, whether our lives are endangered, are taken, our liberty restricted, with or without justification. I'm barred by the fire department from walking home one day to my apartment because they're fighting a fire. My liberty has been impeded. Have my natural rights been violated? My constitutional rights been violated? No, because we think that the restriction was patently justified out of a concern to protect life, including my own life. I saw a youngster a while back on Connecticut Avenue in Washington with a bike he was taking down into the subways. And I said, my goodness, you could do that? You can take a bike into the subways? And he said, yes, but not during rush hour. He understood it's quite reasonable not to take a bike down into the subways in rush hour when people are crowding down there. He didn't think his rights were being impaired because his liberty was being restricted with justification. Now these, I want to point out to you, are simply judgments that ordinary folk make every day. You don't need lawyers to do these things. But then we remind ourselves in the same way that this matter of protecting natural rights was not a function reserved distinctly and solely for judges. It formed, again, the very rationale and justification for the government itself. A government that would protect us in our natural right would be protecting us against private thugs who are assaulting us, as well as, say, thugs from the IRS. The sense of what's been lost from our collective memory on this point may be seen in that case that arose just a couple of years ago when the city government of New York was ordering the inspection of bags, suitcases and bags for people entering the subways because they had an alert to the possible bombing in the subways. Now, people were saying, maybe some constitutional issues may arise in this case. What constitutional issues? What we're more likely to hear is the constitutional right not to be subjected to searches and seizures to have our bags inspected. But the people who saw the Constitution in that way did not see it with the lens of the framers. Because as the framers would have seen it, the government that was ordering the inspection of the bags was seeking to protect the natural right of ordinary people not to have their lives taken in a lawless way through bombings in the subways. See? And when you put it in that way, well, it gives us a different angle. Andrew Bailey is a distinguished professor of computer sciences at Williams College. But when he was a youngster growing up on my block in Amherst, Massachusetts, the son of a dear friend, a professor of mathematics, he was busy mowing lawns in the summer with the object of getting enough money to buy himself a very spiffy English racer. Well, he did get enough money near the end of the summer. He bought that English racer, and on the last day of the summer, the last job, someone stole that bike. Now, John Locke would tell us that Andy had worked all summer for the thief. The thief had appropriated to himself all of Andy's earnings and labor for the summer. He had made of Andy a slave. What this points out is that in the understanding of the founders, a competent government that protected us from theft, protected us from involuntary servitude long before the 13th Amendment. And when you put all these things together, might that not explain what Alexander Hamilton said when he said, the Constitution itself is in every rational respect a Bill of Rights, because the Constitution brings forth a government with the competence to protect people in their lives, their freedom, their property. Okay. When we take natural rights seriously, the defense of natural right, as I say, need not be the work exclusively of judges. And a judge does the work of natural law or natural rights when he engages the canons of reason in the most strenuous way to test the justifications for those measures that are imposed on people with the force of law. But as we test those restrictions, we gauge whether things are justified or unjustified, we are led outside the text of the Constitution to the things that the Constitution never explains or sets down for us, how we gauge the difference between the restrictions that are justified or unjustified. And we must be led back also to the question of who are those beings, those persons who are bearers of rights, and those beings the Constitution protects. Thomas Aquinas said that the divine law, we know through revelation. But the natural law, we know through that reasoning that is accessible to human beings as human beings. We might say natural to human beings. And in my own experience, the simple example that is grasped at once, kids in middle school can get it, you don't need a college education to get it, it's grasped at once, is that fragment that Lincoln wrote for himself when he imagined himself to be engaged in a conversation with an owner of slaves, putting the question, why are you justified making a slave of the black man? Is it because he's less intelligent than you? Ah, beware. The next white man who comes along, more intelligent than you, may rightly enslave you. Is it because he is darker than you? Beware again. The next white man who comes along, with a complexion even lighter than yours, may enslave you. The upshot of this was there's nothing you could cite to disqualify the black man, black people, as rights-bearing beings that would not apply to many whites walking about. Now, what I want to point out to you is that nowhere in this chain of reasoning is there an appeal to faith, to revelation, to religious belief. This is an argument that could be understood across the religious divisions. It could be understood by Catholics, by Baptists, by atheists, by Chicago Cub fans. You don't have to be a genius in order to grasp this sort of thing. Now, in other words, that some of us have used precisely the same mode of argument when it comes to that matter of abortions. We put the question, why is that offspring in the womb anything less than human? Doesn't speak yet? Well, neither do deaf mutes. Doesn't have arms or legs yet? Well, other people lose arms or legs in the course of their lives without losing anything necessary to their standing as human beings to receive the protections of the law. In other words, you don't have to be Catholic or religious to understand this argument. And that has been precisely the argument of the church, that it's not a matter of faith. It's a matter of natural law reasoning. It is a combination of embryology, what we know of the facts of science, woven together with the kind of principled reasoning that Lincoln used. Now, I have a dear friend, Dan Robinson, founder of the neurosciences, done 18 books, now at Oxford, and he said he wanted as the epitaph on his tombstone, he died without a theory. A president of Amherst College remarked one day, Hadley has a theory of natural law. I said, when somebody says something like that, it rather suggests that you're standing back watching these theories whiz past, and somehow you're able to make judgments about the fragments of those theories that are plausible or implausible, true or false, and we say, take us back to the ground on which you're making those judgments about the things you think you can reliably know, and you would take us back to the ground of where some of us understand to be the ground of the natural law, in what Blackstone called the laws of nature and reason. And one of the interesting part in this project of ours that Steve mentioned, on natural rights of the founding, we're trying to restore and recover for another generation the furnishings of mind of those founders, of people like Alexander Hamilton, James, who had this knack of tracing their judgments back to those anchoring axioms of things that were true of necessity as the very ground of their judgments and weaving from there. And so Alexander Hamilton would say, for example, in the Federalist 78, are you kids with me? Okay. We work under this rule of construction, that any later statute overrides an earlier statute. But that's not the rule we work with the Constitution, because the Constitution coming earlier must be able to override the statute or the law coming later, or else it loses its function as a control on the legislative power. But Hamilton asked, well, how do we know this? This rule is not set down anywhere in the Constitution. It's not in the positive law, the law that is posited, enacted. How do we know this? And he says, it's the reason and nature of the thing. Now, John Marshall, Chief Justice Marshall, in a classic case on the Commerce Clause, some of you may read later, called Gibbons versus Ogden, at the very end of the opinion, he apologizes to his readers for spending so much time demonstrating what should stand in the class of an axiom, he said. That is, he assumed that all of his literate readers knew that before you can carry out a demonstration, certain axioms had to be in place. They had to be grasped as true in themselves. So, for example, if you were doing the experiment of the ball rolling down the inclined plane, that the steeper the incline, the faster the ball rolls, and you want to do angle A, angle B, you had to know the difference between A and non-A, or that A is not B. You had to know the law of identity, or you had to know the law of contradiction, A is not A. But if I didn't know that, there'd be no way for me to explain it to you in the form of a demonstration. That's one of those things you had to know before you even step into the demonstration. And that the founders were utterly clear on this point was nowhere expressed with more elegance or compression and economy than Alexander Hamilton in that opening, that introduction he did to the Federalist 31, which is a paper about taxation. And in the course of that paper, he reached no conclusion different from what Senator Dole in our day would reach, or Senator Cornyn. But any disinterested observer looking at the text would notice at once some strikingly different furnishings of mind. And I think the youngsters would appreciate what's being said here. So this is how Hamilton put it. He said, in disquisitions of every kind, there are certain primary truths or first principles upon which all subsequent reasonings must depend. These contain an internal evidence which, antecedent to all reflection or combination, command the assent of the mind. Of this nature are the maxims of geometry. The two lines cannot enclose a space. The two things equal to a third are equal to one another. And of like nature are the maxims of ethics and politics. There cannot be an effect without a cause. That the means must be proportioned to the ends. And there ought to be no limitation placed on a power destined to effect a purpose which is itself incapable of limitation. See, just the way Bob Dole would have said it, I think, if he really just bent his mind to it. The founders showed a remarkable knack of tracing their judgments back in that way. So let me just give you a couple of examples. In a classic case called McCulloch versus Maryland, John Marshall noted that the Constitution gives Congress the power to punish only piracies on the seas. But Congress has the power to establish mails. The power to establish must entail the power to preserve, in this case, to preserve the mails against theft. And so Marshall works it out by simply drawing out the logical implications of having a national government. To say that there's a government at the national level must be there's the power to legislate at the national level. But what could legislation be? What could the powers of making laws be if laws are not to be enforced? But a couple of years earlier, he did something far more elegant. In a case I hope that some of you will read called Fletcher versus Peck, he dealt with a case in Georgia where the legislature rescinded a grant in lands. They found some corruption in it, and it was going to affect many innocent people who were buyers in the second or third degree. He might have just struck this thing down as a law. He considered this a law that impaired the obligation of contracts. It undermined the contracts, earlier contracts, to buy and sell this property. So he might have simply settled this by invoking Article 1, Section 10 of the Constitution on laws in the states that would impair the obligation of contracts. He could have settled it very easily. But instead of doing that, he did something far more elegant. He showed how the contracts clause could be drawn deductively with the force of a syllogism from a deeper principle on ex post facto. Ex post facto laws meaning you're making something punishable after the fact that was not considered wrongful when it was done. And everyone understood this was one of those deep principles of lawfulness that would have to be there in anything that called itself the rule of law. And once Marshall did that, he can come out with this remarkable conclusion. He could say, Georgia is a great state. It is part of the American empire. But even if Georgia were a separate, sovereign state outside the Union, outside the Constitution, outside Article 1, Section 10, this law would still be wrong, because its wrongness is rooted in a proposition that does not depend at all for its validity on being mentioned anywhere in the text of the Constitution. See, what I want to point out to you is that these people have the capacity to trace their judgments back in that way. So I now, as we say, fast forward. And I'm at lunch with an old friend of many years, Justice Antonin Scalia. And I raised the question with him of that important decision in the Second Amendment in the Helen case on the right to bear arms, where the court decided this was not simply a right found in militias, but for ordinary persons. And I said to him, when you wrote that opinion, you were invoking the right of self-preservation, by which I took you to mean the right of an innocent person to fend off an unjustified assault. And he said, yes, quite right. And I said, well, those words are not in the Second Amendment. So what I was wondering, were you appealing to some deep principle that does not depend at all on being mentioned anywhere in the text? Or are you simply saying the right of self-preservation? James Wilson and Blackstone had said it, many people had read them at the time. Well, if it's the second, my point is, you'd be converting jurisprudence into legislative history. We'd now be asking, how many people who voted to draft the Second Amendment and voted to ratify it had actually read Wilson and Blackstone and incorporated them in their understanding? And even if we could get the answer to that question, which we can't, it would not be the answer to the question we're asking, which is there in fact a deep principle that would confirm our right to make use of lethal force, of a lethal weapon, when it seems quite necessary in defense of our lives or our freedom? During the litigation over Obamacare several years ago, my dear friend Greg Katzis, arguing the first day, invoked a line from John Marshall to say that forcing us to make a contract we did not wish by forcing us to buy medical insurance may be as bad as impairing the obligation of a contract we had willingly made. And years later, Justice Joseph Story would say, that principle is so true, it would be there and be true even if there were no Constitution. And John Quincy Adams would later say, the right to petition the government, he was having these petitions over slaves petitioning for their freedom, and he would say, the right to petition the government, a free government, would be there even if it were not mentioned in the text of the Constitution. So part of what we're doing in this project is trying to recover this capacity, this ability of young lawyers and judges to reason in this way back to those principles that would have to be there even if there were no Constitution. My dear friend Dermot O'Scanlan in the Federal Ninth Circuit in Oregon handed down a decision about a year and a half ago in which he struck down an ordinance in San Diego that barred people from carrying guns with them in public, even in areas where they could think that their own lives could be in danger. He made it clear that his opinion found its anchoring ground in Justice Scalia's opinion in the Helen case, appealing to a deep natural right to defend our lives. He said this was a right, as Scalia said, a right that pre-existed the Constitution, that did not depend on the text of the Constitution. And a few years ago, in a piece in the journal First Things on Obamacare and natural right, I argued for a different path of argument that didn't depend on the Commerce Clause, which people were using. And that argument has just brought into play again more recently as more recent cases come up. In a piece in the Wall Street Journal just about a year and a half ago, Mr. Stephen Blackwood reported that his mother was being treated for cancer with a procedure that was fairly pricey, but which came within her medical insurance she could afford. And yet, with Obamacare taking hold, he said her premiums have now, and deductibles have skyrocketed, and she no longer has available to her a procedure manifestly useful in preserving her life and which she'd been able in the past to pay for herself. And as Mr. Blackwood argued, Obamacare has so disarranged the marketed medical insurance and the provision of medical care that the government is actually blocking his mother from the legitimate means of preserving her own life, even at her own expense. And my question, earnestly put, is, why is it plausible and compelling to proclaim a natural right to protect our lives when it comes to the right to bear arms, and not quite as clear and compelling to invoke precisely that same right when it comes to challenging the constitutionality of Obamacare? The Second Amendment doesn't explain the difference because, as Scalia and O'Scanlan have made clear, they're dealing with a pre-existing right that would be there even if there were no Second Amendment and there were no Constitution. About 10 years ago, after I was giving a speech at Fordham Law School, and the dean at dinner, the dean said, you know, the founders, the people in that founding generation never said much about natural law. As my friend Ed Robinson said, yeah, they didn't mention much about the alphabet either. It's just that it just threaded through everything they were doing. And it struck me that it was kind of a species of what the philosophers would call a category mistake, as Mr. Gilbert Ryle at Oxford explained to us years ago. So let's say I'm back at Amherst College and I have a guest, and I'm taking him to show him the college. And I show him the beautiful octagon where I teach, and I show him the social center, and I show him the gym, and I show him the administration building. We come back to the house, we're having a drink, and he said, but I thought you were going to show me the college. I said, well, I thought that's what I've been doing. So these people, like the dean, say, you haven't shown me people doing natural law. All you've shown me are some literate lawyers who keep tracing their judgments back to first principles and the laws of reason and the axioms that would be there even if there were no Constitution. When are you going to show me people doing natural law. And we're saying, you've been seeing it all along. They were doing it all the time. They just never mentioned to you that they were doing it. You've never left it. So the person who tells us, can we do the law without invoking those axioms and principles, is rather like asking the question, can I order the coffee without using syntax? These people discover, with Moliere's old line, they've been speaking prose all their lives without quite knowing it. Well, when we launched this project in natural law 4 years ago, I ended that talk with a plea to our friends who are doing conservative jurisprudence. I said, why should we settle in with a mode of reasoning about the law that gives us a kind of sing-song morality with terms such as activism, which have no moral content? Some think that the effort to address these moral questions at the heart of the law just too risky, too ambitious, too difficult to do well, too likely to license mischief. And our friends have sought safety in cultivating formulas of the positive law while cautioning us not to ask the kinds of questions that run beneath the surface to the core of things. But in that path, I'd argue, there has been no safety, and therefore no prudence, and beyond that, no coherence, because we cannot give our best reasons, our fullest reasons, the reasons that give the most coherent account of the law we are trying to shape when it falls to us to shape it. And the question at the end is, why should we settle for anything so diminished when measured against the moral seriousness of the questions that are before us now? Why wouldn't we rather strengthen our jurisprudence by drawing again on the understanding of that first generation of lawyers, a natural right, a teaching that will always be with us, there to be read and to be learned anew? And where could we find a better assurance that the law we're preserving would be as comprehensible and compelling, as resonant with common sense in the next generation as in our own, and as it will ever be. Thanks very much.